we know there is no such a thing as a 20-minute coffee break. And then, but we need to get on with a very interesting panel on the role of non-lawyer arbitrators in construction disputes. Obviously, non-lawyers play a fundamental role in resolving disputes, but their role on arbitration panels, there are different views. Maybe these views differ in relation to the applicable law, whether you are in a civil law system, in a common law system, in relation, of course, to the nature of the dispute, how much the dispute is of a technical nature, how much dispute is of a legal nature, who are the other arbitrators on the panel, what's the right composition, if there is a non-lawyer, more than one non-lawyer. So all very interesting, and we look forward to this panel chaired by Caroline Pope, a leading arbitration and construction lawyer with 30 years experience in litigation, arbitration, adjudication, ADR processes, including mediation and expert determination. She has been involved in disputes on many iconic construction projects, including multi-party commercial property, PFI, retail, shopping center, and large office developments, and of course in arbitration under the ICC and the DIAC rules. So Caroline, over to you.
Thank you very much, Renato. I'm going to very briefly introduce the panel, but you've got everyone's bios, because I think that last session made us realize how little time each of the panels have. So absolutely delighted, first and foremost, because we must never forget the end users, or the actual users of arbitration, is Sam Kay, who's a principal in-house lawyer at the Kier group, who is responsible for all of Kier's strategic disputes, and historically has a background from White & Case and Pitts & Masons in international arbitration. James Hope from Vinge, he's dual qualified both in Sweden and in the UK, and does international arbitration. Absolutely delighted to be joined by our non-lawyer on this panel. Thank heavens we were able to find one person who's prepared to sit on the panel. Murray Arms. I think most of you will know Murray without a doubt. He's one of the doyens of the expert world for us, and we're delighted to have him and his views. And finally, last but not least, sitting on my left is Virginie Colaiuta. I hope that's right. I apologize if I've got that wrong. And Virginie is, again, both a civil and common law lawyer, dual qualified, or actually probably about quadruple qualified in different jurisdictions. So I'm very pleased to have this panel with me today. That last session that we've just all had before the break, I think brings to the absolute fore how important it may well be going forward for us to have non-lawyers on our panels. The introduction of AI, the age profile of so many of our arbitrators, which I'm afraid I think we all know is probably over 50, and lawyers, perhaps doesn't really fill the clients, and we'll hear from Sam, with enormous amount of confidence as to how they're going to, tribunals going forward in the next 10 years are going to be able to deal with the increasing number of disputes which are undoubtedly going to have AI and digital issues at their center. So that puts this discussion, I think, beautifully in context. And I think it's true to say that over the last, I don't know, 15, 20, 25, I'm beginning to show my age, 30 years, international arbitration has changed. 30 years ago, I think probably there were nearly as many non-lawyer arbitrators as there were arbitrators on the panel. In fact, arbitration was almost in its roots was formed together so that you had more technical experts determining disputes and not lawyers. And we've moved away from that. Some say we've now have a closed shop almost, that lawyers are, that international arbitration is the preserve of lawyers. And indeed, despite the fact that we have already at the heart of so many of our disputes, technical issues, we still find overwhelmingly that our panels are made up of 3 lawyers. So I think this next session, this next 30 minutes, we're going to look at and discuss what role we think non-lawyers can play on arbitral panels, whether they can actually improve the process, whether they can assist in generally working alongside lawyers to make arbitration perhaps more streamlined and more cost effective, which I know will be things which will be music to Sam's ear. I want to just make one thing clear. In this discussion, we've agreed that when we talk about non-lawyers and lawyers, in academics, we're including in lawyers, not in non-lawyers, just so that in case there was any so Renata, you would be a lawyer for this purpose. And actually, before I start, how many of you do think that there is a role for non-lawyers in international arbitration? Okay, can the panel confirm that that's the overwhelming? Because the last panel I chaired, which was on is international arbitration in construction fit for purpose. At the end of the session, I was expecting everyone to put their hands up and say, yes, it was. And the majority of the room said, no, it wasn't, on cost and speed. So anyway, let's go to the panel. That's quite enough for me. This panel is going to be very much you hearing the views and thoughts of the others. So Sam, can I pass to you first and foremost? What we often forget when we're having these sort of discussions, not when we're advising our clients, but when we're discussing in panel sessions, what it is the end user is really looking for, the person who's paying all our bills. So what is it you and your senior commercial teams are looking for? And do they think that perhaps having more non-lawyers on panel, on tribunals could assist, Sam?
Okay, well, thank you for the introduction, Caroline, and it's a pleasure to be here today. So it will generally depend on the nature of the dispute in question. So whether, as the client, we are pursuing the claim or defending the claim, whether the claim is legally complex or highly technical or both. So in answer to your question, Caroline, as a client, there are many factors that we are looking for in the arbitral process, besides, of course, an award in our favour. So I'm going to whiz through 6 of them today. The first one is the usual suspects, confidentiality and flexibility. Second is the choice of tribunal. So the ability to choose a non-lawyer, which we are here today to discuss, is one of the key factors that we're looking for in the arbitral process. And it goes without saying, in my view, that having an arbitrator or a tribunal that has some technical expertise is invaluable if the dispute is technically complex. So in fact, Virginie and I worked on an arbitration some 10 years ago, and we had an engineer arbitrator in the tribunal, and that individual raised questions and engaged with the party appointed experts in a way that the lawyer arbitrators didn't do so, and that might be because they hadn't lived and breathed project life. And I found that it was incredibly helpful for our contractor client. And this leads me on to my third factor, which is obviously the opportunity of the client to be heard. We can all appreciate here that arbitrations are costly and that contractors are operating under incredibly tight margins. So when we do choose to spend that money, and it's a lot of money, pursuing or vigorously defending a claim, we're doing it because it's worth fighting for, it's worth being heard about. So having a tribunal that will give due and detailed consideration to all the issues and arguments that we've raised in the dispute is a key factor as to what that we're looking for in the arbitral process. Fourthly, we're looking for the brave arbitrator. So I was recently speaking with one of my commercial directors, and his view was that he wants an arbitrator that's not afraid to make the bold decisions and embrace contractual provisions rather than to just strike a middle ground with unsatisfactory decisions for both parties. These bold decisions are necessary in the arbitral process. It avoids a party having to issue an arbitration notice because they know they won't walk away empty-handed. And in this view, and in the discussion that I was having with this director in particular, his view was that there needs to be this risk or deterrent that a bold decision will be made by an arbitral tribunal to avoid any party just issuing a notice and taking a punt. And so following on from today's theme, my view is that a lawyer arbitrator would be more likely to make those bold decisions rather than some of the non-lawyers, sorry, Murray, who may steer clear from the complex legal issues or reach a middle ground when it comes to legal interpretation. Fifth point, I promise I'll keep it short, it's a commercial outcome. ultimately, as a client, we don't want to have recourse to a full hearing and the associated costs that come with that. And I think the arbitral process allows plenty of opportunities for the parties to A, state their positions and be heard, be it through witness statements, the exchange of expert reports or pleadings, and therefore narrow the areas of dispute to pave the way for that commercial outcome, which may not have been possible prior to the commencement of the arbitration. And ultimately, for me, one of the factors that as a client we're looking for in the arbitration process is that should an award be rendered in our client's favour, that award is binding and it is enforceable.
Thank you, Sam. I think we'll pick up on quite a number of those points as we go forward. Murray, one of the points that Sam's made is the bold, brave arbitrator, and possibly a suggestion that non-technical arbitrators aren't quite as bold in making those decisions. Could you perhaps talk about what your view is on that particular point, and whether you think actually tribunals are missing out on not having a technical person as one of the tribunal members?
Sure. I mean, I think, certainly from my experience sitting on tribunals, it's very often the technical arbitrator or the technical tribunal member who makes those bold decisions. Maybe not legally, but we're almost there to, I hesitate to use the word disrupt, but certainly to sort of widen the scope of the discussion. So I think we do that. I mean, certainly I do that, not deliberately, not to be obstructive or difficult on the panel, but to assist the discussions, and as I say, to expand the scope of the discussions. Are tribunals missing out? Well, I think non-lawyers probably have a better understanding of the practical aspects of the industry. And you mentioned, Sam, the commercial aspect. You want a commercial decision. Of course, we have to respect the contract and make decisions in accordance with the contracts. Contracts are not always fair, but that doesn't mean to say that an arbitral tribunal, whether it's technical or legal, can just go ahead and make what it considers to be reasonable decisions without reference to the contract. But I think a technical arbitrator can certainly assist the lawyers on the panel to have perhaps more awareness of the commercial decisions. And very recently, a prominent international arbitrator, I was in Singapore, and they having a discussion about this, because he's a great believer in non-lawyer arbitrators, but expressed the view there weren't really very many appointed. And he said, if you air a complex technical issue in front of a panel of 3 lawyers, you are effectively airing that technical issue in front of lay people. Now, I don't want to be insulting to lawyers, but with due respect to lawyers, they perhaps are not going to have that awareness. And you talked, I think, a little bit about questioning experts at the hearing. And again, I think technical experts can engage, or technical arbitrators can engage with those experts in a way that lawyers may not be able to. I've been involved in many arbitrations where I think, and you could say, well, you would say this, wouldn't you, that the lawyer arbitrators have actually got some of the technical issues completely wrong. And I'd like to think that if you have a technical arbitrator on that panel, there will be less decisions that have those potential flaws.
Virginie, do you think there's a risk, therefore, of a third way? You always have the 2 parties tend to have their own experts involved. Do you think there's a perception that by having a third, inverted commas, expert, i.e. the technical person on the panel, there's going to be a third answer to that technical problem?
I believe that actually the combination of experience and knowledge of the various members of a tribunal, to the extent that you have a technical and legal background or legal training and knowledge, is a plus. And I would not advocate, for having, for example, a sole arbitrator acting as a non-lawyer acting as a sole arbitrator. That would create maybe a concern in terms of maybe if the assumption, sorry, Murray, but if the assumption is that a non-lawyer has an imperfect knowledge of the laws and rules and an imperfect understanding of the application of those laws and rules, if this is the presumption, then obviously it makes sense to have someone who has legal background, so that you undermine the possibility of enforcement challenges. And the technical issues, which are the prerogative of non-lawyer arbitrators, are usually not the basis for a challenge for an award, because national courts cannot review typically the merits of a decision during an annulment proceedings. So for that reason, usually the main basis for a challenge is a legal issue. And very often the parties would refer to procedural irregularities to have the enforcement challenged of an award. So to the extent that there is this disparity of knowledge of legal issues, I would assume that the parties would choose to have also lawyers part of their arbitral tribunal. One wonders, though, if, for example, this reasoning should apply also with respect to the dispute boards. It is commonly known that members of a dispute board are very often non-lawyers. And so why there is this there is more attention to nominate a lawyer for arbitral tribunals rather than nominating lawyers in dispute boards. So sorry if I expand my answer to more issues than you actually.
No, not at all, because you actually dealt with one of the points that Sam raised about the importance of enforceability.
Yes.
So from your answer, you're suggesting that actually, provided possibly the panel it's a three-person tribunal, which includes at least one lawyer, to be the presiding lawyer, then you're less likely to have issues on enforcement. Although let's all remember, we sit here feeling very, we shouldn't feel smug as lawyers, because actually it's often awards which are challenged on enforcement actually happen to have been made up by 3 lawyers. So I think it is a point, but I think it's possibly, I hate to say, and I'm being provocative, I fear that actually the argument on enforceability is often one used by lawyers to try and protect the preserve that they have in international arbitration. I might be being cynical, but I'm afraid I'm sometimes known for being cynical. On that point, I'm going to leave that, and perhaps afterwards we'll have a discussion involving the audience as to whether they feel that perhaps I'm being overly cynical, whether I might have a point. James, we heard from Jamie earlier about the LCIA, and actually the fact that I think he was saying that 33% last year of the nominations were made by them, suggesting that wasn't a large number, but that's possibly more than you might think. Do you think that arbitral institutions have a role to play, perhaps, in encouraging or, advancing the role of non-lawyers in tribunals?
Well, thank you.
In terms of panel selection.
Thank you, Caroline. Yes, I do. If I, though, can just start by saying we're talking about a sort of huge dichotomy between lawyers and non-lawyers. And actually, of course, the best people are both. And we all know of some fantastic arbitrators who are both lawyers and engineers, for example. And even if you don't happen to be qualified in that way, I think I'm right in saying, for example, Murray, you have a great deal of knowledge of law, actually. You may not be.
I hope so.
You may not be fully qualified in a certain way, like some other people do, but you nevertheless know an awful about law. And also the best lawyers who deal in construction are actually quite good at technical issues. I know some people went into law because they hated numbers, but I'd like to suggest that if you're one of those people, you probably ought not to be here, because actually it's the numbers that are most important in the end. So to answer your question, I think institutions have a very important role to play, but institutions also need help. I used to sit on the board of the SEC Arbitration Institute in Stockholm, and one of the main jobs, of course, was to appoint arbitrators. We had they do have lots and lots of CVs for lawyers. They're always trying to widen the pool. They don't have many CVs for non-lawyers. So all non-lawyers out there, please do give your CVs to institutions. And I think Jamie said the same thing about the LCIA, because first of all, they need the information. The second thing to say, of course, though, is that when the institution gets involved, it's normally to appoint the sole arbitrator or the chair. And then I think, Virginie, you're absolutely right, that for that role, quite often that's where the legal issues are specifically important. And so maybe we don't always want to have a non-lawyer fulfilling that function, maybe sometimes, but not so much. It's for other roles in the tribunal. What I have seen is that sometimes the institute has to appoint the whole tribunal, and the institute, of course, loves that, because then you can really tailor make your tribunal. And maybe parties should dare to allow that to happen more often, because I would suggest that's actually a much better way of doing it. And then you really would normally think to yourself, well, actually, let's widen the pool a little bit. Let's fashion this tribunal together in a way that will bring in the technical expertise, which is probably so important for so many disputes. I'd also like to suggest, I don't know how many of you have done arbitration in Norway. There's a special way of doing things in Norway, which is quite interesting. They normally have ad hoc arbitration. For some reason, institutional arbitration doesn't happen so much in Norway. But in the ad hoc procedure, what happens in Norway is that all the members of the tribunal are appointed at the same time, at the beginning. I'm doing one of these at the moment, and the tribunal decided who the people would be. So, sorry, the parties decided who the people in the tribunal would be, and then they appointed those people, and thankfully those people were available, so that was fine. But that really meant that they could fashion the tribunal at the start. And this thing that we normally have of having the tactical question of, well, they appointed a lawyer, so who should we appoint? And it becomes a question of tactics. That goes away. It's a question of what's the best tribunal for this dispute. And I think, particularly as you were saying, in the new world of AI, we need to think a bit more in that sort of way, I'd like to suggest.
And James, the parties are prepared in those jurisdictions to sit down and actually try and agree, because so often we know that by the time a dispute gets to a notice of arbitration, parties are loath to agree anything.
Well, you're right. And I'm possibly a bit surprised also that it works so well in Norway, but it does apparently work, partly because that's what the law firms have, that's the procedure they're used to. And I think there's quite a lot of horse trading and discussion and, to and fro, but the fact that it happens at one time, I think that's the point.
And Sam, as the client in that process, what is your view on that as a very different way of selecting the tribunal?
Look, I think it needs the buy-in from all those involved, and most importantly, our instructed solicitors, because at the end of the day, we're here to listen to you. If you are coming to me and saying, here's a list of, for example, middle-aged white men that should be your arbitrators, the problem is going to start a lot earlier. So I think the instructing lawyers also have a duty to come to us and say, here's this panel, it has diversity of thought, we have technical, and let's actually reach out to the other side and agree it together. But obviously we are being told by our instructed solicitors that actually this is in your best interest, so you should have these individuals, rather than actually let's have that dialogue right from the start. And as you allude to, Caroline, sometimes it's too late for the parties themselves to be collaborative because they are in a dispute. So I think a lot of it would be helped by having the instructed solicitors and counsel actually taking the lead on that a bit more.
Well, it's interesting because if you think about dispute boards, Maureen, the parties have broadly actually managed to agree who they'd like on their dispute board, which it suggests that there might be scope if we try and think outside the box, if we want to be more inclusive and more diverse in what we're doing. Perhaps it is a thought that we should be taking to our clients.
Yes, I think so. I mean, some parties agree dispute boards. Sometimes FIDIC or one of the institutions has to appoint because the parties can't agree. But I think it's true. I mean, a point that was made is that you perhaps see more non-lawyers on dispute boards. And that's possibly because your skills in terms of how you understand construction, how you understand how building sites work and construction contracts work is perhaps more important because you're there monitoring the project the beginning. And so that technical expertise is something that the parties have employed you to engage. They've employed you to help them with that. Obviously, in arbitration, things have gone beyond that. But yes, I think there is a greater diversity in DABs, and I think also it's also true that there, I see a lot more diversity, gender diversity, and racial diversity in dispute boards, perhaps more than arbitrations.
Thank you, Murray.
Can I actually volunteer a comment about
Please,
this?
please do.
There is a friend of ours in the audience who just made a comment. I had a discussion on this earlier on. And it depends on whether the intention is to resolve the dispute or to decide the dispute. Because with the dispute boards, the intention is more to try to resolve the dispute as the project goes on. And even though the solution, the decision will not be in fact viewed as final. But with arbitral tribunals, you have more the intention of having really a final decision. And for that reason, the enforcement issue and the fact that legal issues are more important makes the choice for lawyers more more important as well.
I think in theory that's correct, but I would say the majority of dispute boards I'm sitting on are ones where they're meant to be standing boards, but they haven't appointed the dispute board, and all of a sudden they have an enormous dispute. What do? We go to the dispute board for a decision, and I'm working on 3 at the moment. I've got about 4 or 5 that are proper standing boards where we regularly go and visit the site, but I've got 3 at the moment where I have disputes where they haven't had the opportunity of the dispute avoidance process in the first place, so we have to make decisions. And on one of those coming up, a hearing coming up fairly shortly, we have a lawyer who's actually not the chair, we have an engineer who's the chair, and they have me, and I'm not a lawyer. So but we've moved away from arbitration, Caroline. So
no, but it's really important that we learn the lessons of different means of resolving disputes back to because at the end of the day, what we're trying to do here is to assist our clients in resolving their disputes in so many ways. And actually, if one thinks about in the UK adjudication, very, very large disputes are referred to adjudicators now, and many of those adjudicators are not lawyers, and many of those the clients live with. So it doesn't necessarily mean that just because it's a slightly different process, you should have a completely different set of decision makers. Although, albeit, of course, adjudication is only interim binding until if it is finally determined. But so often, Samuel, I'm sure you'll confirm, so many disputes are not then referred to the courts, that clients live with the decision. At the end of the day, we forget how important it is for someone to make a decision, come to decide the dispute, as opposed to actually just be one of the cogs in the process.
And I think to add to that, Caroline, in our discussion earlier, we're also looking at the end, right? The dispute, the relationship's broken down. Actually, maybe we should be thinking about this at the birth of the project, when we're sitting down writing these contracts, that both parties can agree that actually, if we do get to the stage we're in a dispute and we have to constitute an arbitral tribunal, both parties agree that one member should be a non-lawyer, if the parties are minded to do that. So maybe we're looking at this actually too late, and we should be doing that earlier on in the process.
Could I also raise an issue about procedure? Because it seems to me quite often we go through the sort of standard procedure that the lawyers think about, and I know there's going to be a discussion about PO number 1 later and all this sort of stuff. And you go through this process and you end up with a massive decision at the end, but that may not be what you want. You actually want a decision on a number of specific issues which allow you then to either resolve things or whatever. And it occurs to me that if you were looking at it technically, you might figure out the specific technical issues that you need a decision on, but not necessarily all the rest. And the problem is lawyers don't necessarily think like that, but I wonder what your thought is on that.
No, I would agree. At the end of the day, we're here to build a project, right? And make a profit, not to spend those profits on arbitration processes and dispute resolution. So no, I would agree.
I'm just going to ask one final question to the panel before I throw the discussion open to the floor. Virginie, we're lucky we have you and James, both who are common law and civil law advocates. Do you think that there's a different view of technical arbitrators held by people from civil law jurisdictions to us adversarial common law lawyers?
Thank you actually for this question. And I do not think that the nomination of non-lawyer arbitrators would be happening more often, or be more recurrent in civil law jurisdictions, or in any event in arbitral panels or for parties from civil law or common law jurisdictions. What I though think that in an extreme scenario, for instance, where you have a non-lawyer arbitrator who might bring the attention or the discussion with the parties and the arbitrators on technical evidence or arguments which have not been spontaneously, for example, raised by the parties, then if you have a civil law approach, you might in fact have a different, end up to have a different result, because the inquisitorial approach might encourage the arbitral tribunal to investigate further on issues and encourage a debate that is more open on those technical and arguments or evidence. Obviously, this is controversial because many would assume that the arbitral tribunal is not supposed to encourage discussions or open up arguments or investigate new evidence that the parties have not volunteered. But this is not an obvious issue, because some parties, and some can explain that, because we had a discussion on this point, would prefer to have that kind of generous opening of arguments and also requests for new evidence from the arbitrators, because that would encourage either a settlement discussion between the parties, or because some evidence or arguments that the one party, for example, who is a weaker party, has not raised, could in fact be protected or encouraged in its defense. I don't know what you think about this.
Yes, I mean, certainly perhaps my experience on civil law is more to do with the dispute boards. And of course, the dispute boards are exactly that. They are inquisitorial.
Mm-hmm.
And I think they're effective because of that. You know, maybe the tribunals need to be given more flexibility to ask more questions and be more inquisitorial and get to the real heart of the dispute.
Now, is it part of your experience, for example, that a non-lawyer arbitrator has asked questions on arguments or evidence which were not volunteered by the parties?
I think I'd be very hesitant to do that.
Yeah.
It would be more about asking if I thought that there was something missing, asking very carefully worded, open questions without actually leading them, because otherwise you're helping them make a case for themselves.
Yeah, but these are not legal arguments. So that's why, because there are technical arguments, you might feel more having more flexibility to ask these kind of questions to the parties.
I think it's beneficial. Certainly in dispute boards, it's beneficial. But I think when you're sitting on an arbitral tribunal, you have to be very careful you don't overstep the line and become an advocate.
Yeah.
Yes, I think that feeds back into something I know Sam said in discussion. I don't think we mentioned as we today, but in discussion we had before, which is how important it is that is a line that you feel you've been heard, and sometimes possibly at least getting the sense from a non-lawyer on a tribunal, or possibly even a lawyer, that they're at least understanding your argument as the hearing is progressing, even if they're not going to finally decide in your favour, would give clients more confidence in the process.
Yeah, definitely, and also that fresh pair of eyes review, or the review having considered both sides' expert evidence, for example, and their pleadings and witness statements. So no, I would say that it's all helpful, but ideally we want to avoid the hearing completely.
Altogether.
And if by doing that, that would help in the earlier stages, then that's obviously a benefit to the client, maybe not to the lawyers involved, but.
Anybody got any questions that you could? Well, 2, 3. That's fantastic. 4. Oh, stop, please. Let's take the gentleman right at the very back. Birch, that's you, the front row of the back. First, I'll come back to you guys in a second. Is that right? Can I take 3 questions? And then.
Thank you very much. Georg Scherb from Clyde & Cohen, Hamburg. I'm very much in favor of sort of technical expertise on arbitral tribunals. I have not had the experience yet of non-lawyers on a tribunal. What we have had in complex offshore wind disputes, nuclear power plant disputes, that we sometimes had it sounds kind of weird, an education day or Q&A day before the hearing or on the first day of the hearing, where a third independent expert answers questions from the tribunal to basically bring them up to speed on certain technical issues. And I think that is very appealing, especially in complex disputes. The problem I see with appointing non-lawyers, technical arbitrators, is that if one party appoints a non-lawyer who has significant technical expertise, from a counsel perspective, I would advise my client to do exactly the same. And then we have 2 non-lawyers on the tribunal and the poor chairman or woman sitting in the middle having to decide between 2 experts and 2 experts before them. So that's the challenge sort of I see in bringing technical expertise to the tribunal without sort of tempting each party to appoint also a technical arbitrator. I'm not sure whether it was a question or a comment, but
I'm going to take that as an observation, because I haven't got time to ask the panel for their views. There are another couple. Renata says I can ask 1 or 2 more questions if those people who put their hands up still have the question. Anya.
Related. To what extent can the issues be solved by a tribunal expert?
Laurie?
Well, I would like to think you don't need a tribunal appointed expert if your own party appointed experts are capable of explaining the issues to the tribunal. Certainly that, I think that's a better solution. I think there's all sorts of problems with tribunal appointed experts, especially if you also have party appointed experts. Are they going to align? Is it just going to take you down another rabbit hole? I think you have to be careful.
Sorry, may I say that I disagree with what you said? Because if you have a non-lawyer, a technical arbitrator, part of the tribunal, having discussions and explanations on technical issues without the collaboration of the parties will not be able to comment on those explanations. And so the decision making is not affected in any way by what are the parties have no control on whether the explanation is correct or not. And so you need, I believe, an expert to be appointed by either the tribunal or by the parties, explaining what are the explanations for certain technical issues. You cannot have a discussion among the arbitrators on their own, even though there is an excellent technical arbitrator able to give an explanation.
But I think you can have a discussion based on the evidence that you've heard.
Yes, but that discussion has to be with the parties, and the parties must be able to present their own arguments and counter argue whatever explanation that the arbitrator, technical arbitrator is given. Because
Could I interrupt and say we could go on all afternoon on this fascinating topic, because this really goes to the heart of it, and it seems to me that the real problem for the tribunal, I mean, I think of this also as someone who sat in tribunals, is how do you find your expert? And that maybe goes to your question, that it's very difficult to find somebody who's a tribunal appointed expert whom everybody trusts.
well, but the parties can always nominate a party appointed expert, even though there is an expert nominated by the arbitral tribunal. So at the end, the idea is that the parties should be able to play the debate on an equal basis with the knowledge and the arguments that they want, and in open kind of discussion. Yeah,
I think that's right. I think the risk is that it's doing the opposite of what Sam wants, which is increasing the length of time it's going to get to an award and the cost. But at that point, I'll hand over to you.
Yeah, thank you very much. And I think this last exchange between Virginie and Murray, I think it's an example of technical arbitrators and lawyers on the panel. So whether you want that or not, here you are. You have a real life experiments to that. But thank you very much. I think it was a very interesting panel, a lot about selection of arbitrators, but we have seen how it feeds into advocacy, pleadings, decision making, costs, and so on. My own view is that if all three arbitrators are truly absolutely independent, then I would be quite comfortable to have one technical arbitrator, one lawyer, and so on and so forth. The risk is that sometimes, unfortunately, in international arbitration, you still have arbitrators who are slightly, let's say, bending towards one side of the argument or the other, and then having uneven expertise on the tribunal, and I think might be a little bit more risky. But I think I agree we could discuss the whole afternoon, and we can't do that because we have to move to the next panel. But thank you very much. That was extremely interesting.